Mr. Mears, you may proceed.
So much paper, you would think we ought to live in an electronic world or something like that. Good morning. My name is Philip Mears. I'm an attorney from Iowa City. I'm here to talk to you about something very different than what you've been hearing for the last half hour. I represent Ross Barker, who is a convicted sex offender, and this is about his registration under the sex offender registry statute. Before the Ross Barker case, I represented David Jensen, which was a prior case that ended at the Court of Appeals. They had a common theme, which was in both cases at the time of the sentencing judge gave the defendant what we now understand was wrong information about the length of registration. I think one of the hardest things I do as a lawyer, or have done as a lawyer, is when a client comes to me and said, this is what the judge said. Why can they say something different? And I have to try to explain decisions like in the Jensen case or the Barker case, most recently from the Court of Appeals, which essentially said that it didn't matter what that judge said. And it didn't matter that after the judge said that, you went and served your sentence, but that what the judge said can be ignored by the other side. I think the facts are relatively clear, but that they bring together so many parts of the kind of practice I've done for the last 40 years that it's a wonderful case. Mr. Barker was convicted of assault with intent, an incredibly unusual statute in the world of sex offenses, in that it is an aggravated misdemeanor. It's not a felony, but that the legislature in 1999 defined it as an aggravated offense for purposes of giving people lifetime on the sex offender registry. There's been an incredible amount of confusion about that statute and that length of registration for a really long time. I had a prosecutor a year and a half ago tell me that registration for assault with intent was only 10 years. I had a judge.
Doesn't the case kind of boil down to this? And I have to say I'm troubled by it. The issue is when the appellate courts make a mistake, and that mistake is the basis for a decision, is that mistake rightly or wrongly binding on the court system thereafter? Is that what it comes down to?
Absolutely. And I do think it's important to draw a distinction between Jensen and Barker, because what you had in Jensen and what you had in Barker, just as an initial matter, was the sentencing court making a mistake about the length of registration. And this court 16 years ago said that it really wasn't the sentencing court's business to get into the length of registration. That for that matter, if a judge made a pronouncement at the time of sentencing about the length of registration, that was surplusage and just didn't count. Now, I happen to have thought in Jensen that there still should have been the requirement that somebody went into that court to seek to vacate that part of the sentencing order. How hard is that? But they didn't do that. But Jensen is Jensen, and Jensen is based on Bullock, and says that a sentencing court's statement about the length of registration is not enforceable. But in this case, as you pointed out, you had that registration is probably a collateral consequence to a guilty plea. It's not required to be discussed, even though the courts have long said that you can't give misinformation about a collateral consequence. And that applies to not only the lawyer for the defendant, but presumably the judge as well. That Barker, after he found out that he was facing lifetime, not the 10 years, filed a post-conviction case in 2014. It kind of got botched up at the district court level by the lawyer in terms of trying to argue the way around essentially the statute of limitations. But the claim was, I was misinformed about the length of registration and that this was material to me and I wanted to pull my plea. It gets dismissed at the district court level on statute of limitations. It goes up to the Court of Appeals, and I don't know why the Court of Appeals made the mistake that arguably there's some language that you can look at that might be ambiguous unless you read the next paragraph, but they decided to deny Barker's appeal based on the fact that he wasn't misled. Court of Appeals said you only have to register for 10 years. His lawyer didn't sit on that and decide that was a good ruling, but in fact applied for further review to the Iowa Supreme Court, pointing out that that was just wrong.
Okay, so you have, I think, some of the elements of a potential collateral estoppel in place, but the state presses a view, as you know, that the state's not really unitary. There's a criminal prosecution element of the state, and then we have a Department of Public Safety. And the state points to a couple cases, one involving license suspensions in DOT, where you've got the DOT is an administrative agency operating and the state bringing criminal charges. And then also points to a case involving investigation of sex abuse matters where the Department of Human Services is kind of a separate agency. To cut to the chase, the point is, well, collateral estoppel usually requires, although not always, but usually requires identity of parties. This is really kind of different, particularly when the legislature has vested DPS with certain powers. Anyway, you understand the general nature of my inquiry, so why don't you?
Absolutely. And those cases actually provide support, I think, for our position, because clearly those cases could have been, the DHS case and the DOT case could have been decided solely on the grounds of lack of mutuality, that the DOT or DHS wasn't party, they're not bound. But that clearly, the court never decides that, never addresses that, assumes the fact that the state is the state. And those cases turn on a legislative commitment of a general subject, that is, whether implied consent procedures have been followed or whether or not there's been child abuse after a factual hearing, turn those matters over to the agency. And for that reason,
And they turn it over to the Department of Public Safety here? The calculation of...
No. I mean, that there's certainly some pronouncement in some of the cases about how this is all committed to the Department.
Bullock, I mean...
Well, sure, but Bullock is 2002. Lots changed. That is, that at this 2009, today, that there is no sentencing case where the judge can't determine whether or not there's registration required. You simply look up the code section in 692-101, that in those ambiguous, we had, before 2009, we had a bunch of cases where you might have to register if it was an offense against a minor, for example, and that you could plead to child endangerment. And child endangerment doesn't have the word sex in the statute, and that you might not know whether you were going to have to register. That before 2009, you might have to have an administrative hearing to resolve the fact question of whether or not your facts involved an offense against a minor. That as of 2009, complete change. Today, you have the determination made by the court, the sentencing court, as to whether or not there's a sexual motivation.
Well, the state argues, I think, that there's a special competence issue, namely, to take the DHS case first, that involved investigations with respect to sex abuse. DHS has got a lot of experience in this and has, kind of specialized competence. You just indicated that our courts haven't done a terrific job, perhaps, in navigating the statutes. Why isn't there I'll call it special competence exception to the application of collateral estoppel in this case? Because the legislature has directed the Department of Public Safety to analyze these issues, and the Department of Public Safety has a special competence in the area.
I don't think there's any special competency involved in looking at 692A 101 and saying you pled to this charge, and here it is, and that it is a Tier 1, Tier 2, or 3. It's not described as an aggravated offense, and this is your first offense, that's 10 years.
Let me, again, at the risk of oversimplifying the matter, I mean, even if what the Iowa Court of Appeals said in the prior case is not binding on the Department of Public Health, isn't it binding on us, on the court system? And that's where we are now?
Well, I mean, it's binding for purposes of Mr. Barker and his determination. I mean, the problem,
It's just another, once it's decided and there's a final decision, doesn't that bind the court system?
well, you could have made the same argument in the Grant and the Heitzman case too. I mean, it's almost self-fulfilling to say that it's not binding on the court.
Well, here's what I'm getting at, Mr. Mears. We have another doctrine that I didn't see discussed a whole lot, but it's related, which is the law of the case doctrine, and that says the doctrine of the law of the case represents the practice of courts to refuse to reconsider what has been once decided. Pursuant to this rule, legal principles announced and the views expressed by a reviewing court in an opinion, right or wrong, are binding throughout the further progress of the case upon the litigants, the trial court, and this court in further appeals. Is that principle potentially applicable?
Oh, I think so. I mean, I cited a really old case of mine, the Feller decision from, I think, the 80s or 90s, where the case first comes up to the Court of Appeals and an issue is resolved and then goes back, and the Supreme Court eventually takes further review in that case, but says we might have disagreed with the Court of Appeals as to how they decided it, but we're stuck with that decision.
I have a more basic question. Is the requirement to register as a sex offender a sentencing matter, or is it an administrative matter?
I think it's a sentencing matter, even though it's kind of indirect. I mean, there's some discussion in the briefs about the requirement of the sentencing court to
If you read Chapter 9, Section 905, dealing with sentencing, there's nothing in there about ordering sex offender registration.
Well, there is, I think, in 692A, an obligation imposed on the court to
Form.
give certain information for people who are not being sentenced to prison. There's also a provision in 692 requiring the assessment of a civil penalty for everyone who has to register. It's $250 or something like that. And that I think actually that provision, deciding whether or not that provision applies, is something the sentencing court has to do.
Does the sentencing court have to tell someone who's convicted of a felony they lose the right to vote? And all the other collateral consequences that
No,
come
I'm-
with a conviction?
No, I'm saying that 692A imposes certain obligations on a sentencing court with
That
regard
to
to sex
inform.
offender registry.
To inform, but it does leave it up to the Department of, whatever department it is, Department of Public Safety, to decide the length of time. Because someone will register, and if they think their registration's up, they apply to the Department of Public
Oh,
Safety.
I'm not arguing that there is a requirement that the sentencing court tell people about the length of registration. What I'm saying is that if the court, perhaps incorrectly, tells them wrong, they may have a post-conviction based on that misinformation, and that the court, in ruling on the post-conviction, has to make a judgment, or no, has to make a fact determination as to the length of registration and whether the information provided previously was incorrect. That's what happened here, that there was clear jurisdiction for the post-conviction court and the Court of Appeals to make its pronouncement and to look at the length of registration. They got it wrong, and it's our position that Mr. Barker should, well, that the Department of Public Safety is not free to say, we're going to pay no attention to that decision. Doesn't matter that they got it wrong. We can override that.
Mr. Mears, thank you.
See, my time is up.
Mr. Lundquist.
Thank you, Your Honor. May it please the court. Mr. Mears, my name's John Lundquist. I'm from the Attorney General's office, and I'm representing the Department of Public Safety this morning in this matter. I think this case boils down to the Department of Public Safety was asked a question. It answered that question, and all parties agree that in answering that question, it correctly applied the Iowa Code. That there were no errors made by the Department of Public Safety in interpreting Chapter 692A and determining that Ross Barker had in fact been convicted of what is characterized as an aggravated offense under Chapter 692A. And as a result of that, he is required to register for life as a sex offender in the state of Iowa.
Right, so the Court of Appeals was wrong. I think that's not subject to dispute. And the question is, what is the consequence of that wrong decision? And it seems clear that the Court of Appeals dismissed his PCR on the ground that he wasn't misled at the time of trial with respect to the registration requirement. So the state, at least in the PCR proceeding, has prevailed based on this erroneous interpretation of law. Doesn't that make it kind of difficult for us then to turn around and say in this proceeding, well, that was then and this is now?
Well, I think that I disagree a little bit with your characterization of what the Court of Appeals did in the prior PCR matter. The district court had dismissed the case on statute of limitations grounds. No one had ever argued to that court, or for that matter to the district court, or to the Court of Appeals, that this gentleman wasn't required to register for anything but life. No one advocated to the Court of Appeals that 10 years was the appropriate time
I
period.
mean, when that opinion came out and it was wrong and that was the basis for the decision, the state could have filed for rehearing or something with the Court of Appeals and said we should win, but not on this ground. You're wrong about this, Court of Appeals. And they didn't do that. And so now we do have a decision. You would agree that if hypothetically this was an appeal, there was an appeal from the Department of Public Safety, I think you said Department of Public Health, Department of Public Safety, and we ruled wrongly that there wasn't lifetime registration, you'd be bound by that, whether we were right about the law or wrong about the law. Isn't that true?
Within the scope of that case, you're correct. You discussed the law of the case doctrine earlier, and my understanding of that is that binds the litigants and those parties in further proceedings that take place in that matter. So if
I agree, it's not a perfect fit, and you're right about that, because technically this is a separate case, except it's really tied up with the criminal case prosecution, Mr. Barker, isn't it?
Well, this court has held that registration is an administrative function of the Department of Public Safety. It's not a sentencing matter. It is a collateral consequence of that judgment being entered. And to circle back to Justice Appel, to answer your question as to why I don't think the Court of Appeals opinion necessarily means what it's being portrayed to mean, is the court says there's no record before us that establishes that there is lifetime registration requirement. Therefore, based on what we're reviewing in front of us, we don't have an evidentiary basis to determine that there was in fact the necessary Strickland prejudice to find that counsel was ineffective down below, to send it back and determine whether or not there was an excuse for the statute of limitations not being met. The place to have made that evidentiary record was by filing a determination with the Department of Public Safety. The Department of Public Safety could have ruled on that determination, as it's, by this court has said, is its job that the legislature has given it to initially do, is to file that determination. DPS, more likely than not, would have said it's lifetime, and then
Unless they took the position it's not ripe and you have to wait until it's ripe, which would be kind of problematic in the context of trying to litigate a timely PCR.
that did not happen in this case before the agency. Obviously, that's a position that I offered as an alternative, and I'm not necessarily to advocate for that position here today. But as you know, this is an administrative proceeding, and that under the Administrative Procedure Act, you can't seek judicial relief until you've been prejudiced. It doesn't mean that the department can't issue that determination. In fact, we're required to, within 90 days under the statute, to issue that determination. And so Mr. Barker could have gotten that determination from the department, then could have filed his PCR, then could have had that piece of paper to show both the district court and ultimately the Court of Appeals that, yes, I have been prejudiced, because at least DPS, whether you agree with me or not, Court of Appeals, is saying I have to register for life. And so I don't think we have a judicial pronouncement in this particular case that hinged solely on the fact that the Court of Appeals misinterpreted or determined that 10 years was in fact the time period for which registration was required, that there was more involved in that ruling than simply that mispronouncement of law.
You make a nice point, but at the end of the day, the ruling turned on the misunderstanding of law, did it not?
I think it turned on the fact that there was a lack of prejudice demonstrated by the record. And
Because of the statute, because of their interpretation. of the
well,
statute.
I think that is can be inferred from the words that were used, yes.
What about the issue of special competence? You heard me raise that a little bit, and it seems to me, arguably in what we're calling the DHS case, there might be some experiential experiential expertise in child abuse investigations. They've investigated 10,000 of them over the period of years and so forth. Here, Mr. Mears suggests that what we're dealing with is, kind of mechanical legal question, and that the Department of Public Safety doesn't have any particular expertise as compared to a court.
I would disagree with that, because the Department of Public Safety is charged with multiple things in the administration of the sex offender registry. The first being that, is this person convicted of an offense for which registration is required? There are some offenses that straight out put you on the list. It's not that hard to determine. Others do require some sort of factual inquiry. The second part of that, which is implicated here, is how long does someone need to be on the registry? Now, if you're convicted of an aggravated offense, yes, it's lifetime registration. But if you're not, then an inquiry needs to be made as to total time, how long someone's been in prison,
But this seems to be the
and the
stuff
like.
I'm sorry to talk over you, but this seems to be the stuff that courts do all the time. I mean, we line up the statutes, and it's a little bit like pipe fitting. Sometimes they fit and sometimes they don't, and, we're trying to figure out exception 3A, 3B, 3C, et cetera. But it strikes me in this case, and obviously I invite you to correct me, what we're dealing here is really a question of legal interpretation, and not one that ordinarily the Department of Public Safety would be in a superior position to decide compared to a court.
Well, that's true, I think, in a lot of different contexts in which both the DOT and the Heidemann case and the DHS and the Grant case, part of their ministerial duties involve a lot of things that courts do. They make adjudications. They look at the information. They plug it into the statute. That's what DPS is doing here as well. And why did this court grant those exceptions in the other two cases for that special competency? Well, primarily because the legislature decided that they should have a fair and first shot at making that determination, and that's what happens in this case as well, as this court has ruled in the Bullock matter, that until DPS actually makes an adjudication, that any judicial pronouncement on that is premature and without effect and not binding going forward. You know, Bullock itself.
On that same issue regarding whether or not there's any special competency, or if there's a traffic case, for example, and the magistrate finds the defendant was speeding and says, I'm going to fine you $500, and then the clerk's office corrects him and says, no, you can't, it's a statutory scheduled fine. It's kind of like this. It's the court's job to find whether or not the defendant committed the offense of sexual, I can't remember exactly what it was, the aggravated offense. And then it's already statutory whether or not he or she would be on the registry. Okay, so I think everybody admits there were mistakes every step of the way. I want to hear more about the issue preclusion. I kind of feel like the Court of Appeals did address the issue that was raised, and that issue preclusion is very concerning to me. Can you help me on that one?
Yeah, I think that the first matter that was addressed earlier with the concept of mutuality. You know, the Department of Public Safety is not the state. This court has not held that the state is the state is the state. That in the context of other things such as perfecting service in 17A proceedings, you know, there's a 1979 case record v. Iowa Merit Employment, that serving one agency is not the same as serving, you know, the state or another agency. The Cujos versus Sioux City case talks about that one agency cannot override another agency's statutory duty. And so we do give agencies certain standing in that regard. DPS was not given a full and fair opportunity to litigate the question of registration in this particular case because no one knew it was going to be an issue until the Court of Appeals issued its ruling, because everyone just assumed that it was lifetime. That was the accusation made by Mr. Barker, and the state never contested that throughout that earlier PCR matter. Plus, the Department of Public Safety has no statutory authority to appear in a criminal case, or any other case for that matter, and represent itself and to present on behalf of the state of Iowa.
Sure, so the PCR court was faced with at least a challenge that the plea was involuntary. The question isn't really whether the sentence is lifetime or not. The question is whether the plea was involuntary. And we all, I think, recognize our case laws, and if there was a material misrepresentation of fact that actually impacted it, that's probably an involuntary plea. So the PCR court had to address that issue, or could have gone off on other grounds, I suppose, but the PCR court addressed the issue. Now, it's true enough that Department of Public Safety wasn't there as a party. Everybody agrees to that. But the court, in the context of an involuntary plea, basically said, well, guess what? No prejudice, because 10 years is 10 years. Doesn't that bind the Department of Public Health? Or Public Health, Department of Public Safety. These issues are so intertwined. It seems, kind of frankly, on a very guttural level, kind of unfair. And that's what our more fancy pants doctrines of law, the case and collateral estoppel, designed to address.
Well, I think, to keep following up on Justice Christensen's question, is we don't have to decide the issue of mutuality. We can just look at the question, was this fact actually litigated? And I think based on the case law, it wasn't actually litigated. No one advocated the position. No evidentiary record was made. That's part of the reason why the Court of Appeals dismissed the PCR. And so the elements of issue preclusion are not met in this particular case.
I mean, you know, we can get into all this technical stuff, and we will. And there's some real live issues here. But, I mean, from the perspective of Mr. Barker, he lost his PCR for that reason, all right? He can't get anything done with his conviction now at this point. So if he lost it for a basis he shouldn't have lost it, there's nothing can be done about that now. And you're saying, well, notwithstanding that, we're gonna give him the registration.
Well, keep in mind that the context of this challenge, this is a 17A challenge to agency action. This is not a post-conviction court. DPS has no authority to overturn or validate that plea. All we can do is interpret the statute and give our determination, which is what we've done. Now that we've gone through that process, can Mr. Barker go back to the PCR court and make the argument that I have this new statement of fact that would, in fact, override the statute of limitations ground? You know, I don't know, potentially. But the place to make that argument is in his collateral PCR that he currently has stayed, that he'll have the opportunity to make that argument there that I have reasons why this PCR should go forward. It's not per se barred, but there is an opportunity to make those arguments in the PCR court. And in this particular proceeding, the state made its determination. That was a correct determination, and for the reasons cited, I would ask that that be affirmed. So, thank you.
Mr. Lundquist, thank you as well. Mr. Mears, you may present your rebuttal argument.
I think it was in the Grant case. Actually, it's a quote that occurs in several of these cases involving preclusion, that one big reason for preclusion is to avoid two authoritative but conflicting answers being given to the very same question. Ross Barker had a post-conviction appeal where the Court of Appeals said, you only have to register for 10 years and therefore your post-conviction is denied. There actually was a suggestion from Mr. Lundquist, and I think from the Court of Appeals in this case, well, maybe Mr. Barker could go back and do another post-conviction. I actually filed a post-conviction for him at the same time I filed the 17A, and that's been put on hold. But I've done post-convictions for a long time. There's no way you're going to avoid, quite frankly, preclusion in a third post-conviction based on the fact that the second post-conviction decision was wrong. That there's no new fact. I can't bring a new fact of law in. He's got zero chance in that new post-conviction of being able to get around that Court of Appeals decision from 2015. That if this court, or the Court of Appeals in this case, said that your registration is lifetime and it doesn't matter what the Court of Appeals said, that he's going to
Counsel,
have...
would he have pled guilty in 2008 had the judge told him, by the way, lifetime registration? Would that have changed his mind?
That's what he said in his pleading in 2015, or 14.
And based on a new, if hypothetically we rule that, DPS is not bound by the, mistake of the judicial branch, and it is lifetime, isn't that a new ground of fact or law that could breathe new life into your PCR that's on hold?
I think it would breathe some life into it, but not really. I mean, everybody knew in 2014 and 15 what the length of registration was, except for the Court of Appeals, it seems like. That he pled that he was told that it was lifetime, and that's why he wanted to to file his post-conviction. I mean,
Would we be setting a dangerous precedent if we decreed that DPS is now bound by this 10-year mistake, and that's his registration ends at year 10?
I thought about that. I mean, I've had some cases in front of this court that affected lots and lots of people and were big issues. I don't see this as really being a major precedent that where you're going to have too many cases where there's going to be a Court of Appeals decision in a post-conviction that gets a fact wrong with regarding the length of registration. This is pretty much a one-timer. But the principle, it seems to me, is that the Court of Appeals in 2015 had clear jurisdiction and had to answer the question of was he misled? That is, that the courts sometimes have to decide what in fact is that collateral consequence. Somebody comes in and says, I wouldn't have pled to my OWI if I had known that I would lose my license for 6 years. That it becomes a fact question what that collateral consequence is, and if the court gets it wrong, then you have this case. But that I don't see this as coming up in other cases. A couple of other real quick responses that Mr. Lundquist said. Mr. Barker just asked the DPS what the length of his registration was. He actually asked them, don't you have to follow the Court of Appeals decision, which said it's only 10 years. That, again, Mr. Barker has been authoritatively told that he only has to register for 10 years. There's now a district court and a Court of Appeals decision that says you have to register for life, and that we are asking this court as the last court of resort, I believe.
I'm going to violate that red light there and ask one more question. You just said, I don't think that's going to make a big deal. I think this is a one-time shot. What about those cases where the district court screws up and forgets to revoke a driver's license for 6 years, and then later on you get a letter from the DOT saying, hey, judge, you screwed up. Statute says 6 years. We call that an illegal sentence, and we fix it. That happens very often. How about the case where there's an assault committed in a penitentiary and the district court mistakenly said concurrent sentencing on 2 charges when come to find out the statute requires consecutive, and we get a letter from the Department of Corrections that says you screwed up, judge. So I can see those cases being argued and using your case as an example why, hey, you know what, issue preclusion, maybe there's been some, maybe the Court of Appeals makes a mistake again. I am concerned because unfortunately district court judges, that's why we have the Mullins chart, there are some very confusing statutes at sentencing time.
But this case is not Jensen. This case is not about whether there was a problem because Barker's sentencing judge screwed up. That can presumably be corrected. Motions to correct illegal sentence are out there all the time. That this is about the example you gave about the person not being told about the 6-year loss of license. If that person took a post-conviction and tried to pull his plea, and there was a ruling of the post-conviction court that you're wrong, in fact, what was done originally was correct, that's this case. That is, this case is not about just correcting sentencing mistakes. This case is about the DPS being stuck with a decision in a post-conviction appeal where a court clearly has the authority and required to address that, whether or not the statement about the collateral consequence was misleading and material to the guilty plea.
Mr. Mears, thank you.
Thank you so much for your time.
Mr. Lundquist, thank you again. The case of Barker versus Iowa Department of Public Safety is now then submitted, and the bailiff may adjourn court.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.